Hi, I'm Bijlani from Esquired Bar Prep. In this short segment, you'll see me working with my friend Leslie on a portion of contract formation, specifically the doctrine of offer. Many law students and bar takers focus on memorization, trying to memorize every rule word for word. But the real challenge is turning that memorized law into something you can use. At Esquired, I call that process turning doctrine into tools. It's about seeing how each rule functions, what problem it solves, how it operates in context, so that memorized concepts become a flexible toolkit for reasoning on exams, and in turn, the reasoning allows for easier memorization. Here I'm walking Leslie through an excerpt from my carefully crafted substantive law book, showing how to digest the material rather than just memorizing it. Normally, I don't sit with students like this endlessly, just talking about the substantive law like other bar providers do. Our one on one sessions focus on building the lawyering skills that the bar exam actually tests. Hard skills like issue spotting and analysis, arguments, eye racking, and soft skills like time management and anxiety abatement, etc. So, as you watch, notice not only what the rule of offer says, but how we work with it, turning memorized law into actionable skills. And if this helps with your bar prep, hit subscribe so you don't miss future lessons. Then we get into the first big topic, which is formation. Formation is, again, the handshake. Let's make a deal. All right. So, one thing when we're talking about formation is to understand that we need, of course, an offer, we need an acceptance, we need consideration, and nothing went wrong during that handshake phase. And so the offer is very important to keeping track of who the offeror is versus the offeree is going to be important because only an offeror can make an offer and only offeree can make an acceptance. So you want to assess the actions of each person, whether you're talking about offer or offeree, offeror or offeree. An offer is where the first party, the offeror, says, I got something for you. I want to work with you. So what do we need for it to be a valid offer in order to bind the offeree as an accepting party? You need a manifestation of an intent to contract with specific and definite terms, and it's communicated to the operator. This is all common sense. Bar law is all about common sense. But what do these words even mean? What is a manifestation of an intent to contract? A manifestation of intent to contract means some sort of outward showing that you want to make a deal. It's got to be outward, something that indicates, yeah, let's do this together. Okay. Specific and definite terms in the essential terms. That means that you want to be able to have something that's workable and detailed, right? It's got to be for sure, which is the definite part, and specific, which means the detailed part. So, an advertisement.
Well, just go ahead about that one.
Yeah.
What I notice many times when I'm doing the practice and MBEs is that they like to ask tricky things in that specific and definite because I've seen questions that they say, like, for example, they didn't decide the date or the price wasn't exact, right? Because they throw it out there. So there's a way to find out the price, but they don't give you the exact price. Would you have a valid contract information?
Great question.
I see that a lot.
Yeah. Well, let's take a look over here. What are some examples of essential terms? If you're dealing with a real estate transaction, you can see that you do want to have a price in there and a description of the property, right? When the stakes are so high that the price really matters, that's going to be important. So typically you're going to see that not just in real estate, but, pretty much every transaction. And it can't be a moving target unless it's some sort of estimate because it's got to be basically reasonable in terms of what it is for the other person to say, okay, I'm good to hang on, and to say that I want to be bound to this contract. For a sale of good, uh, you know, price is going to be important. How many goods, quantity, and you want to also think about when it comes to quantity, keywords like, all of these widgets or only these widgets that are stored in Burrito, that sort of thing. So that is enough to say, hey, I know that there's some sort of definiteness going on. Lawyers are wordsmiths. So when you are trying to assess that the element of specific and definite terms, you want to see, was that really specific? Was that really definite enough to work with, to be able to create the power of acceptance in the other party? An advertisement is something that doesn't have that, right? So why? Because ads are not very specific about those kind of details typically. It's just an invitation to treat. Why don't you come over and enjoy our resort? You know? So it's that sort of thing. It doesn't tell you how much the rooms are. It doesn't tell you what services are included. So that's what you want to be careful with. Sometimes there may be scenarios where you might think, oh, this may not just be an advertisement, even though it kind of reads like an advertisement. It's a handbill that was put on my door, and the handbill doesn't have that has all these details, which is the price, the kind of service being offered. Now suddenly, is that really just an advertisement? You're going to want to reason it out based on specificity and definiteness, which is why I put advertisements under that element. That's where you want to think about that. And then the last element of offer is fairly simple. It's communicating. The other party, you've got to know that an offer is being made to them. So it's very logical as to why we have these elements for an offer. Now, an offer could end, and it can terminate. And there are multiple ways that an offer could end. The first one is it lapses. It expires. When does an offer expire? Within reasonable time, or if it's expressly stated in the offer. This lasts only until X date. It could be that the offeror, remember we're going to keep our offeror and offeree in check, revokes the offer. And basically a tip is to look for a statement or conduct by the offeror that could indicate that they are revoking their offer. And what you need is an unambiguous statement or conduct to not be willing to enter into the contract anymore. Unambiguous means that it was very clear indication. I don't want to work with you. Even though before I indicated I wanted to. And it need only be published in the same manner as an offer. And if it's mailed or if you're not in the same location, it's not valid until the offeree receives it.
That's one of the tricky things that I always see, because the revocation is also when I'm thinking about revocation and then acceptance. This little rule of like when you mail for the revocation, it's only when the person receives.
Right.
But for acceptance, it's the minute you mail it's already you accepted, right?
Now let's think the logic behind that, right? So meanwhile, we're thinking of someone who is sees an offer already, and they're still wondering, "Ooh, this is a good deal," or they're shopping around for other offers. How would they know that that's not on the table anymore if they haven't seen the revocation? So that's why it makes sense for the revocation to be valid only after it has been received. Right? So think about the logic behind bar law. Most bar law is not, it doesn't defy common sense. So think about why would it be this way, and that will help us memorize it better. Then there's got to be, of course, that awareness fit, which is what we're talking about on the part of the offeree. And even if the offeror didn't tell the offeree directly that this offer has been revoked, did they find out some other way, and if that's reliable, right? Okay. And it had to be before the acceptance, because of course, if they've already accepted, they can't. Yeah. So that's a logical element to have. And here's some types of offers that are irrevocable. And I gave you a little mnemonic called POOF. Promissory estoppel, the offer for a unilateral contract, an offer for an options contract, and then there's the firm offer rule. This is where you cannot take back your offer once you have made it. And one is promissory estoppel, also known as detrimental reliance. I relied on this, and now you took it away from me. For example, as you see a general contractor relying on a subcontractor's bid to score a contract with the city. They relied on that, and you can't just take that away from them, right? So, but it's got to be foreseeable, right? It's got to be expected that at some point that could, that the other party would rely on, that the offeree would rely on it. Offers for unilateral contracts are not revocable. That's where you have begun some sort of performance toward the contract. And once you've done that, or it commands that you accept by performance, we can't just say, okay, we're done, because we don't know what sort of background story that person has engaged in to accept that offer through performance. Now, then there's the options contract. An option contract is the offeror promises to keep an offer open, and the offeree gives consideration. Okay, so in that situation, you would not be able to revoke. And an option is terminated when an offeree accepts an option, or the offeree rejects the option, and an offeree contracts with a third party during that period of the option. So that's how an option gets terminated. I kind of threw that in that piece because that's really where we only see options becoming a big problem. Then there's also the firm offer rule, which is a UCC only rule, not for common law. So you need a sale of goods, and an offer is open for 3 months, and the party is a merchant, and it's separately signed and written promise. Another way one could terminate an offer is by rejection. Now, this action is by the offeree. So you have, when you're thinking of rejection, it's about what the offeree has done to terminate the offer. No more. I don't want to play with you. And that's the rejection, right? So they can reject by making some sort of counteroffer. A counteroffer is a type of rejection. It kills the offer and acts as a new offer that the offeror now must accept. So now we're switching places. Now the offeree becomes the offeror, and then the power of acceptance comes in with the original offeror, okay, in the counteroffer. So,
And they like to play with them also.
Yep.
But I remember seeing many that they show that they put a condition, and then it's confusing if it was a counteroffer or not, if it can be considered a counteroffer or not, because sometimes it's just a clarification and then it's not a counteroffer, but there's always the option of a counteroffer to get you confused.
Yes. And they love to test on that confusion.
Yeah.
So this is why I put counteroffer under rejection, which is specifically under offers, which is specifically under formation, because you want to think about what phase you're in to see if you can classify it as a counteroffer, or is it just an additional term of the contract, or is it just a different term of the contract? So if you mess up that bearing as to where you are in the phases of the contract, then you're likely to, your analysis will fall apart. Exactly. So when you're looking at a counteroffer, what we're doing is we're applying the reasonable person standard to determine whether it's really a counteroffer, or it's just a little bit more of bargaining, negotiation, fine tuning. A counteroffer is often a statement about what they want and not want. Typically, what they don't want. I don't want what you just told me. A bargaining is just often asking a question, a clarification, like you said. So that wouldn't constitute a counteroffer. There's also a conditional acceptance. The term must be a deal breaker in order for it to be a counteroffer, and not just an additional term, right? So, for example, it says, on the condition that only if, sounds like deal breaker language to me. If they say that, then they've made a counteroffer. Okay?
There's always, I remember always checking they talk about arbitration. Sometimes they send it back.
We'll get to that.
Okay.
Yes. Is that a deal breaker or not? We'll talk about that in a minute. So, death or incapacity is another way to, of course, terminate an offer by one of the parties. The exception is that there is part performance of the offer to enter into a unilateral contract. Someone could step in the shoes of that performance. And so, therefore, the offer hasn't expired, hasn't terminated, or an option, someone could exercise that option. All right. That's what it looks like to turn doctrine into tools, moving beyond rote memorization to transform a rule like offer into a flexible instrument for reasoning and analysis. In my regular sessions, we use that foundation to strengthen the lawyering skills that the bar exam actually measures, skills in applying, comparing, and justifying your legal analysis. If this approach resonates with you, subscribe and explore more at Esquired Bar, where we help you move from memorization to true law knowledge and the practical skills to pass with confidence. Because memorizing the law is just one step, learning to use it is what gets you Esquired.